No one's quite sure what's going to happen here today, so just relax. What are the Miranda warnings? Well, if you're a police officer, what do you say? Yes?
You have the right to remain silent. You have the right to remain silent. Anything you say can and will be used against you.
I don't think will.
Or
Can.
can.
Because if it hurts the police, they won't use it.
You have a right to a lawyer during the interrogation process.
You cannot afford one will be provided for you.
Yes. Now, there's also, it's arguable about whether or not there's a fifth. Do you understand these rights? The FBI, as I recall, and most police officers add this. You can exercise this right at any time. Because what happens is sometimes the defendant will say, well, yeah, I'll talk to you. But then midway through this, I think I need a lawyer. Is that good enough? Or does he have to say, I want a lawyer? He says, I think I need a lawyer. All right. Now, are you sure? Because you could really help, and it may be that we'll be able to get you a much better deal if you talk. Or does I think I need a lawyer, does that force the police to stop? So there's the... They mentioned Escobedo in the film. This was pre-Miranda, and this did indicate that confessions must be voluntary, and that in the whole context of interrogation, there may be a coercive atmosphere.
The key word is trial. The Sixth Amendment gives everyone the right to counsel in all criminal prosecutions, which everyone assumed meant in court. But in a case called Escobedo, that's how it was pronounced in court, Escobedo versus Illinois, the Supreme Court recognized that suspects needed lawyers even before their case came to trial. But how long before?
If you don't have the right to counsel during police interrogation, then your right to counsel at trial is meaningless. You've given the entire thing up. You've given it away. There's nothing for counsel to do at trial because you've confessed.
And in Escobedo, it had been established you had a right to counsel when you had become the focus of the investigation, whatever that meant.
That had created a lot of confusion.
So what happened was, and I was trying criminal cases then, minor criminal cases mostly, and the jury would be in panel, everything's ready to go, and trial courts, just from a manner of management, are difficult. You have to have a jury, you have to have the witnesses present, the police have to be off duty so that they can testify that day, and so the defense lawyers love to disrupt the trial. I mean, you guys guilty probably anyway, so anything you can do to delay. And so they're opening a statement, and we're going to show that he confessed. Oh, Your Honor, please excuse the jury. Now we want to have a 2-day hearing on whether or not this was a voluntary confession. Then you call other policemen in, tell us how long the confession was. Did he want to go to the bathroom, or was he hungry, or did you show your guns? Did you pound on the table? And after Miranda came, I'd stand up and say, oh, now, Judge, we need a hearing. He said, was the defendant given his Miranda rights? And the prosecution said, yes, Mr. Kennedy, sit down, go on. So it was really much more efficient. And in a sense, we thought was actually pro-prosecution. It was actually pro-prosecution in a sense. Let me ask you this question. If you are a foreign national, a national of Mexico, Peru, France, China, and you're arrested, we have a treaty that says the police have to advise you of, well, the treaty doesn't quite say that, but the treaty says you have a right to have the counsel for your country contacted. So if you're a Mexican national, you're arrested in Los Angeles, you have a right to have the Mexican counsel advised that you're being held, and then the Mexican counsel can get you an attorney, notify your family, and so forth. Would you add that to the Miranda warning? So number 5 or number 6 would be, And if you're a foreign national, you have a right to have us notify the Mexican consul right away. Why can't the Supreme Court just say, you add this to the Miranda rights? Yes, ma'am.
In a sense, it's already in the Miranda rights. It says you have the right to an attorney. It doesn't say that the attorney has to be from the United States or from the country that they come from.
Yes, you could argue that, but if Miranda is designed to make the law more workable, more enforceable, more efficient, why not add it? There's a reason, a different reason for not adding it. You're indicating that maybe you don't have to. I want to assume that there are going to be cases where if you don't ask, you're going to have a strong challenge, say, to the evidence and so forth. Yes?
The legal systems may vary, so then there would be complications within, say, them trying to understand our legal system, and then just, they might not think that they are guilty, and it might cause a bigger problem than initially started.
Well, your answers that you've all given are really somewhat more philosophical than I was looking for, and they're good answers. I think the big reason we didn't add it is because we don't want to change the Miranda warning. One of the wonderful things about the Supreme Court and the American constitutional system and the American legal system is we have a high degree of compliance. You can't believe that in some countries, Russia being an example, even some Western European countries, the Supreme Court will say something that you say in Russia you cannot collect a tax between two certain provinces because it violates the Russian Constitution. The next day they're out there collecting the tax. We have a very high degree of compliance. If the Supreme Court says you can't have prayer in public schools, in 48 hours the word goes out. No prayer in the classroom. Miranda warning, the word went out. You saw the policeman studying. Everybody knows the Miranda warning. And if you start to change it, to alter it, to play with it, then you've got an education problem. And there could be other things that we could put in the Miranda warning to make it more complete. So just the administrative aspects of start tinkering with it are quite costly. How many of you have read, and you can be honest about this, have read the Constitution of the United States cover to cover? My mind wanders, particularly the first parts of it. And although I can do it, you can do it because we're familiar with it. For me, I see things that I didn't see, so my mind will wander in the right direction. But it's a little tough to read it cover to cover. But if you're looking for criminal procedure rights, look in the Bill of Rights.
The right to counsel is a Sixth Amendment right. The right against self-incrimination doesn't come from the Sixth Amendment, it comes from the Fifth.
Nothing in the Fifth Amendment mentions having a lawyer at any of these things.
Before Miranda, everyone thought the Fifth Amendment really only applied at a trial or at one of these.
I respectfully decline to answer on the grounds that my answer might tend to incriminate me.
In fact, invoking the right against self-incrimination came to be known as taking the Fifth. The lawyers present at a trial or these hearings understood they had to respect those rights, but no one thought this right applied to the interrogation room, when lawyers weren't around, but where most confessions took place.
And this little book also had the Declaration of Independence. That you can read. It's like an indictment against King George. The more you read it, the madder you get. And it was designed to be read to the troops, to get them mad. And this was the rest of the world said, the Americans say they want freedom. These are the freest people we've ever had. They seem to pay taxes when they want. They dump the tea in the harbor. They got all the land they need. And so we needed a justification for what we're doing. And this is a magnificent justification. There's a great phrase in the Declaration of Independence about life. What is it? Life?
Liberty and pursuit of happiness.
Did you say property?
I did.
Is that a big mistake? Where did you hear life, liberty, property?
I had a couple teachers tell it to me at one point in middle school.
So you think you're wrong if I say pursuit of happiness? You withdraw your answer?
I
Where is life, liberty, property?
That I don't know.
Ah, take a look at the Fifth Amendment. Amendment 5. Take your time. Can you give him the page? I don't know if it's paginated for you. It would be Amendment 5, page 22, your colleagues say. See, I'm going to make you read this Constitution.
It does say property.
What's it say?
Nor be deprived of life, liberty, or property without due process.
So you were right. So why not happiness? Why wasn't this magnificent document that the world knew, that Jefferson himself wrote, part of the Fifth Amendment? Why did they use happiness? Strike that. Why did they use property rather than happiness?
Because they can guarantee that. You can't guarantee happiness per se.
I think that's the answer. If you have judges enforcing what makes you happy, I mean, what's the standard? What are the legal traditions? What are the precedents we have? What are the guidelines? Now, maybe they weren't so much thinking about judicial enforceability, but you know, the Constitution is very good. The framers didn't make a single promise they weren't prepared to live with at the time they made it. So I think you're right. It's just it doesn't have enough of a specificity for it to be really enforceable. What was different about the Miranda case, do you think, than other cases you've read? I come and I take this from you, or I go into your pocket when you're terribly offended. That is called an illegal.
An illegal act, search and seizure.
And so illegal search or an illegal seizure or both. So we know what that is. It's a violation of a specific guarantee, search. It's probably a search and a seizure. How is the Miranda case a little bit different?
Because in this case, Justice Kennedy, the defendant...
Nice and out for your people in the back.
Well, in this case, the defendant wrote out his confession under the circumstances which may have been a little obscure, but in any case, at that time, the written confession was all the state thought they would need in order to convict.
Yes, well, your answer is responsive. My question was not quite focused enough. From a standpoint of jurisprudential method, of Supreme Court methods, what's different about Miranda than, say, a search and seizure case? We ask, what is a search? It is violating your personal space. What is a seizure? It's taking some property from you in a tangible way. How is the Miranda case a little different? Yes.
I think in the Miranda cases, they say in the opinion that the judges wanted to provide some really concrete rules that the police officers could use to guarantee the rights that are in the Constitution.
What authority does the Supreme Court of the United States have to make rules? Suppose you have a statute, and there is such a statute passed by the Congress, that says what you ask before you admit or reject a confession is whether or not in all the circumstances of the case it was coercive. Were there threats? Was he intelligent? Was he terrified? Was he intimidated? Suppose you have a criminal defense attorney he's arrested for fraud. You have to give him his Miranda rights? Suppose you arrest a judge. You have to give him his Miranda rights? I mean, this is silly. Why don't you look at all of the factors in the case? That's what Congress said should happen. And that's the Dickerson case. Congress, by a statute, told the Supreme Court, you've gone too far. You've made these rules. You're not following just the text of the Constitution. You've made these rules. And we want you to look at all the circumstances of the case. No one factor is determinative. And that comes to the Supreme Court in Dickerson.
In 2000, James Hundley, this is him right here, James Hunley successfully argued Dickerson versus the United States. In that decision, Chief Justice William Rehnquist wrote for the 7-2 majority that Miranda is embedded in the national culture.
He said Miranda is probably the best-known criminal decision of the past 50 years, at least. It's been shown that law enforcement has worked with it for many years and learned to work with it effectively.
It did have a big effect on people who were less likely to stand up for themselves against the government. It did make them aware that they had constitutional rights that the government was bound to respect.
So Dickerson basically asked whether Miranda should be overruled as a constitutional requirement because Congress has stepped in and had its own theory, its own test, which protects rights. In the long run, it can't be coerced. And the Supreme Court in Dickerson, and Chief Justice Rehnquist wrote the opinion. Chief Justice signs the opinion to himself. And we had quite a debate on this in the conference as to what we should do. And he doesn't say that this is necessarily compelled from the text. It's not like what is a seizure. It's what is a general rule of police conduct. And in a very artful opinion, he says this has become part of our national culture. Is that the way we interpret the Constitution of the United States? In the Second Amendment, right to bear arms. We say, oh, well, it's part of our natural culture, so that's what we're... Hello? I thought what we were supposed to do is interpreting the Constitution. But the Dickerson case, I know there were two. I think it was 7-2. Justice Scalia, Justice Thomas dissenting. We said no, the Miranda rule stays. But the opinion is written differently. Miranda is a little, I have to say, it's just a little bit different. It's a tremendous importance. There's a movie that we saw just the other night called Captain Phillips. Has anybody seen it or heard of it? What happens when they finally have the terrorist, the leader, the pirate, in the ship, and they throw him down and put his hand? What happened? It's an American ship. What would you advise if you're counsel on board the American ship and the Marines or whoever it is arrest this guy? Put him in there. They're ready to take him down to the brig. They give him his Miranda rights. This is a great teaching lesson. Does our country look foolish when the world says that we got this pirate and you use the Miranda rights? What do you think? Would you put that in the movie? I mean, it was real. Would you have done that if you'd have been there on that ship?
Possibly, yes.
You seem a little doubtful, possibly. What happens if you don't?
There could be a lot of implications there.
What's the most obvious implication when they start talking to him? None of his statements can be used against him. He's doing, 30 years in a U.S. prison now? I think it's very important for you to know how essential constitutional guarantees are to the idea of freedom. Have you read 1984? George Orwell's 1984? One of the most you have to read it, and you have to read Arthur Koestler, Darkness at Noon. You have to know what happened in Nazi Germany. You have to know what happened in Stalinist Russia. This is in my own lifetime. Where people were lined up against walls and shot, mass burials, beatings. One human doing this to another. You have to understand that this is a world we live in. And America stands for something. We teach something. This is who we are. This is what we mean. The Declaration of Independence, Thomas Jefferson says, why is he writing? A decent respect for the opinion of mankind require that we give our reasons. We have to teach who we are. And in 1984, Winston Smith, 1984 is full of, it was written in 1948, so Orwell made it 1984. The guy's name is Smith, last name, but first name Winston. You know, kind of an upper class name, but then Smith. It's filled. So he is being interrogated by the state, by the police, and they want him to say that 2 and 2 is 5, just to teach him. And he's not going to do that. But finally, he can't stand the pain anymore, and this happens. And he finally says 2 and 2 are 5, and the beatings continue. And they say, we're going to continue to torture you until you believe it. It's a horrifying scene.
That's no use, Winston. You're lying. You still think there are 4.
How can I help seeing what's in front of my eyes? 2 and 2 are 4.
Sometimes. We've had all that out before. Sometimes they are 4, sometimes, if the state says so, they are 5. How many fingers?
I'm trying to see 5.
Which do you want? To persuade me that you see 5, or really to see them?
Really to see them.
This emergency exception, Quarles, I'm pretty sure this was the case where they arrested the guy in the grocery store, but he hid his gun. And it was behind the bananas or behind the lettuce or something. And so now the arresting are going to take him away, but they've got this loaded gun where a kid can find it. And so the Supreme Court said that it's all right to question him without the Miranda warnings to see where this gun is because it's an emergency. And you mentioned, you know, suppose there's a ticking bomb. So we have to elaborate the emergency exception in a way that doesn't breach the Miranda rule. Let me ask you this. You have a right to silence. Wife is missing. Neighbors report or family reports the wife is missing. 2 weeks later, her body is found, she's been murdered. The husband has said nothing for 2 weeks. Can you use that against him at trial?
Yes.
I thought you had a right to be silent. He said, wait a minute. I've got my Constitution here, Fifth Amendment. I've got the Miranda case, right to silence.
But I think, Justice Kennedy, that the court can still use that fact and say it, that he didn't say anything for 2 weeks. He has the right to remain silent.
Oh, well, how about this in questioning? I invoke my Miranda warnings. And you say, have you seen this? I say nothing. You can't use that. I'm exercising my rights. What's going on here? The husband, the defendant, was not in custody. Miranda doesn't apply unless you're in custody. This is damning evidence where the husband, who purportedly has a good relationship with his wife, they're living together, doesn't say that she's missing for 2 weeks, for heaven's sake. Of course it's admissible. So be careful about this right to silence thing. Have you ever heard of the phrase rule of law? What's the rule of law mean? What's the rule of law mean? Yeah.
From the highest person to the lowest person, the government is going to grant everyone the same procedures so that I know if the law says A, that I can compel the government to do A by a legal procedure.
Okay, Hitler had a rule, if you were Jewish, you had to wear a yellow star. Everybody applies to everybody, if you're Jewish. Is that the rule of law? That's not the rule of law. I was in China. I teach in China sometimes. And somebody asked me, what's the rule of law? And the Chinese like answers with 3 parts. So I thought, you know, this is really interesting. I haven't thought of this. So I said, number one, the government's bound. Number two, the law protects human rights and human dignity. Number three, the law is accessible. And so that's the and the UN adopted this as the definition of the rule of law for the empowerment of the poor. And it's been, because of where we are, it's been translated in many languages on the flip side. And I was going to bring the Spanish, but I picked up the wrong thing. But you can hand these out. The little bookmarks with this definition of the rule of law. That's also something you could talk about. Well, I've
Please join me in thanking Justice Kennedy.
well, thank you.